Did you know that if you're collecting money from the government and you get a job in secret, you could be charged with a violation of the Welfare and Institutions Code, section 10980, that carries up to 3 years state prison? Comment below if you think this is a little extreme for welfare fraud. So we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was arrested for domestic violence and child abuse. Let's see. Mr. Carlos Aguirre tells us, my stepdaughter of 14 years old, my 14-year-old stepdaughter, was coming home late. I already warned her that I would punish her for this, so one night she arrived late and I hit her. My wife was against this, and I hit my wife accidentally. My stepdaughter fell and broke her nose. The police arrived and I was arrested. Well, I mean, it sounds to me that if you hit your wife accidentally, like let's say you turned and you hit her, you didn't do it on purpose, so you shouldn't get charged with domestic violence, or at least you shouldn't be convicted of domestic violence, although you'll probably get charged with it. Now, your daughter running away and falling, tripping, and breaking her nose, once again, that's her running away, falling, tripping, and breaking her nose. That's not your issue. However, the DA's office might make it your issue, even though you may not have done anything to her, and you could be charged with a violation of 273A, which is child endangerment. Now, in terms of punishing your 14-year-old, as long as you hit her in a way to where you didn't leave her any marks, cuts, bruises, welts, it's perfectly legal to... corporal punishment is perfectly legal here in the state of California. You just can't take it to extreme. If you do, you're going to get charged with child abuse. It seems like this is a situation where your attorney is going to have to go to court, obtain all the evidence. A new court date is going to have to be set so that a private investigator can discuss this case more thoroughly with the attorney and also with any witnesses and with the victims. Hopefully your private investigator could obtain or will have the ability to obtain inconsistent statements from what was told to the police, because you don't want to be put in a situation where you may have to take your case to trial to defend yourself here. Now, in the event that you do have to take your case to trial, then they're going to have to bring in 12 people from the community. They're going to have to listen to all the evidence, and then they're going to have to decide, unfortunately, based on their feelings, whether or not you're innocent or guilty. If they find you innocent, well, then they will drop the charges. But based on this fact pattern, you shouldn't be found guilty of any of these offenses, but weird things happen in court. That's why it's important to take these things to trial when necessary. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below. But if you've been accused of a crime and need representation here in the San Francisco Bay Area, call us now for free consultation at 1-800-862-7677. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers. DUI lawyer, DUI lawyers. Criminal attorney, criminal attorneys. DUI attorney, DUI attorneys.